many of you, I'm sure, know Greg Peterson from the Robert Jackson Center. We're doing this presentation in partnership, and I will call on him to introduce today's speaker.
Welcome, everybody. Thank you. All right, here we go. Baseball. You thought you were coming to listen to Felix Frankfurter. Wrong. Okay. He just segued perfectly into next week. We're going to talk about Albion Tourget. What he did not mention is the fact that Albion Tourget, Mayville, New York, there's a Wayfarer right up as you're going towards Tops Markets. You'll see a blue sign. That's the home of Albion Tourget. And if you go a little bit further to the right and you go down to the cemetery, he's actually buried there. But he was the prosecutor who presented the case at the United States Supreme Court of Plessy versus Ferguson. Albion Tourget. We've actually had some conversation about that. So maybe Brad might figure out a way to segue a little bit into Plessy versus Ferguson, Frankfurter, Jackson, move that all in. But most importantly, I'm wearing this in honor of Brad because he is a baseball guy. He's a Georgetown Law professor. I'll get into that in a second. But after attending Duke University, get his bachelor's in arts, he wrote A Well-Paid Slave, Curt Flood's Fight for Free Agency in Professional Sports, the Curt Flood story. And that's how I came across him. I saw him in front of the United States Supreme Court. Justice Sotomayor was at she was the sole judge in what was sort of a reimagination of an argument before the Supreme Court on the Curt Flood case, the Antitrust Reserve Clause case. And the guy who did the introduction was a guy named Brad Snyder. And Brad Snyder, I bought his book. Brad Snyder actually autographed it to me. That was the beginning of a beautiful relationship. And so this is part of him. And in addition, after graduating from Duke in 1994, he spent 2 years as a reporter for the Baltimore Sun, where he covered the Baltimore Orioles for a season and a half, as well as other things. And while covering the Orioles, Snyder wrote a 14-part series on Cal Ripken Jr. during the season that Ripken broke Lou Gehrig's consecutive game streak. And it was there that at the same time he was witnessed to a Supreme Court case, which then got him a little bit juiced up about law. So he's a Baltimore Orioles fan. In case you've looked at the schedule recently, shockingly, wonder of wonders, hopes of hopes. He all the way up, he told me he was wearing his Baltimore Orioles hat, but didn't want to wear it today. He wasn't sure of his audience. And I said, it's okay. I'll do the baseball part. This is, by the way, the Jamestown Tarp Skunks have a doubleheader tomorrow. That's the end of the baseball story. A little bit more about Brad and his professional career. Georgetown Law professor, as I said, he teaches constitutional law, civil procedure, legal justice, 20th century American legal history, and sports law. He has written 2 critically acclaimed books about baseball and numerous law articles about constitutional history, including the Supreme Court's mishandling of the case of Julius and Ethel Rosenberg. I'm giving you ideas of what questions you might want to ask later on. The divided jurisprudence of Chief Justice John Roberts, based on his judicial clerkship with Henry Friendly and Justice Rehnquist. And he's been seen in a contributing article on Slate, Washington Post, ESPN, C-SPAN, and HBO, and how you can go from ESPN to C-SPAN and baseball and all that. It's fantastic. He served as a law clerk for the Honorable Dorothy Nelson on the U.S. Court of Appeals for the Ninth Circuit. For nearly 3 years, he worked as an associate of Williams & Connolly, LLP, a Washington, D.C. law firm. And for 8 years, he lived 2 blocks away from the still-standing House of Truth. Before he joined the Georgetown Law faculty in 2017, Snyder taught for 9 years at the University of Wisconsin Law School. The reason he is here today, aside from baseball, is the fact that he wrote this wonderful, critically acclaimed read the New York Times, read the Wall Street Journal, Democratic Justice, Felix Frankfurter, the Supreme Court, and the Making of the Liberal Establishment. So without any further ado, Professor Brad Snyder.
wow, there really is no better hype man than Greg Peterson, right? I mean, there isn't. I mean, I wish I could take him on the road with me. I seriously want to thank John Schmitz, Greg, who's become a friend, and Kristen McMahon and everyone at the Robert Jackson Center. I'm a huge fan of Robert Jackson's work and have learned a lot about him in writing this book. And one of the things I learned about writing about Robert Jackson was that he was Felix Frankfurter's closest friend on the Supreme Court of the United States. And when Frankfurter came up here with the other justices to Jamestown for Jackson's funeral, he wrote a letter to his other very close friend, a Second Circuit Court of Appeals judge with the best name ever, Learned Hand. And when he wrote Learned Hand, he said, Jackson sure is the hometown boy. Right, that was his sort of reaction to seeing Jackson's heyday as a Jamestown lawyer and all of the people that he knew. And really, the segue into my book is that what I learned in law school, and most people, their received wisdom about Felix Frankfurter was that he was this liberal lawyer who became this very conservative justice. And indeed, after Jackson died in October of 1954, just a few months after Brown versus Board of Education, Felix Frankfurter's life on the court was never really the same again, right? He found himself at loggerheads with Earl Warren and many of the liberal justices, and he was sort of put in the kind of dustbin of history, right, as kind of out of step with the most liberal Supreme Court in our history. But funny things happened in the last 20 years or so. People have begun to take a second look at Felix Frankfurter and his views about the role of the Supreme Court in our democracy, and they say, hey, maybe he might be right. And I want to try to explain what I mean by that. My book makes kind of two claims. One is that Frankfurter really created the 20th century liberal establishment as a professor at Harvard Law School for 25 years, and then as a justice on the Supreme Court for 23, by counseling all the great legal minds in our country not to go to a New York law firm, not to go to a Boston law firm or a Chicago law firm or a Washington law firm, but to go into public service. And that produced spectacular results. And I'm going to talk about that a little bit. And the second claim that I make in the book, and one that really relates to a lot to today, is that Frankfurter viewed the Supreme Court of the United States as a historically reactionary institution, backward-looking, and that should play a limited role in our democracy. He saw this idea of judicial restraint as a liberal constitutional theory. Look at, they agree, right? And so my argument in the book is that Frankfurter wasn't some liberal lawyer turned conservative justice. He was the same guy. He was a liberal lawyer implementing a liberal constitutional theory of judicial restraint, right? This idea that the Supreme Court of the United States should defer to the elected members of our state governments and our federal governments with one big exception, and that's on issues of race. I'll get to all of that. I'll give you a brief overview of Frankfurter's life story because it's an incredible American story, and how he really became enamored with this idea of judicial restraint, and how he really became just a huge believer in our democracy and in the power of our elected officials. So Frankfurter arrived in this country from Austria. He was a Jewish immigrant. He had never heard a word of English. He couldn't speak a word of English. He arrives in Lower Manhattan, and he has a public school teacher by the name of Miss Hogan. And he was in PS 25 in a largely German-speaking neighborhood. And Miss Hogan threatened Frankfurter's classmates with corporal punishment, because he could do that in those days, and said, if anybody speaks to him in his native German, I'm going to rap you on the knuckles. No one did. And Frankfurter credits Miss Hogan with his sort of acculturation and his quickly learning English. And he was, by the time he graduated elementary school, he was salutatorian of his class. He scored well enough on the entrance exam to CCNY, which was a free combined high school and college program for anyone in New York City, and allowed immigrants from all over the world to make just a rapid rise into our country. He finishes third in his class at CCNY. He's 19 years old by this point, having graduated high school and college from CCNY. He works for a year in the New York City Tenement House Department. At the time, he tries out a couple of law schools in New York. He tries out New York Law School. He tries out NYU Law School. He doesn't like any of them. And then someone at the Tenement House Department says, "My brother goes to Harvard Law School. You should go there too." And in those days, just about anybody could get into Harvard Law School. What was really hard was staying there, because a third of the first-year class flunked out. And so Frankfurter enrolls at Harvard by virtue of his academic record. And during his second year of law school, there's a really important Supreme Court decision that gets decided. This is 1905. And just about every lawyer who's ever gone to law school has learned it. It's called Lochner versus New York. And it was a decision saying that you can't set a maximum hour law, you, the state of New York, can't set a maximum hour law for bakers, because that violates the liberty of contract. And this court in 1905 was anti-worker and really anti-labor. And the justices on the court, they didn't explicitly say this, but they thought that the bakers' union had captured the New York legislature and was responsible for this law. And so the court struck it down. Well, that had a huge impact on Frankfurter in seeing the court as conservative, reactionary, anti-worker, anti-labor, pro-big business. And there was a dissent in that case by Oliver Wendell Holmes Jr. There were two dissents, but one of the dissents was by Oliver Wendell Holmes Jr., and he said, somewhat cryptically, he said the 14th Amendment doesn't enact Mr. Herbert Spencer's social statics. Well, what does that mean in English? Right, well, Herbert Spencer was a 19th century libertarian philosopher who actually coined the phrase survival of the fittest and believed in very limited government. And what Holmes was doing in his own way was accusing his colleagues of reading their economic views, their personal economic views, into the 14th Amendment of the Constitution, specifically into the Due Process Clause, to prevent economic regulation. And that had a huge impact on Frankfurter as a law student. The other thing that had a huge impact on Frankfurter was this law review article that was written by a professor named James Bradley Thayer, who had died shortly before Frankfurter enrolled at Harvard. But Thayer's article was really the first major piece of constitutional theory. And Thayer's theory was as follows, that the Supreme Court should not strike down a federal law unless it's unconstitutional beyond a reasonable doubt. And the reason why Thayer thought that, because if the Supreme Court was too hands-on in striking down federal legislation, that it would subvert the democratic political process, and it would undermine any incentive people had to use the democratic political process. Well, that was Oliver Wendell Holmes's preferred constitutional theory. That was a Boston lawyer named Louis Brandeis's constitutional theory, and lo and behold, that became Felix Frankfurter's constitutional theory, and one that he brings with him all the way through his time as a lawyer and all the way through his time on the Supreme Court. So Frankfurter graduates from law school first in his class at Harvard, and he can't find a job. Because in those days, Wall Street law firms didn't hire Jews. He finally lands a job at Harvard Law School with a firm. One of the lawyers at the firm asked him to change his name to something less funny sounding. He didn't take them up on that offer, but he did join the firm. He lasted 2 months. After 2 months, he gets a phone call from the new prosecutor, the new chief federal prosecutor in the Southern District of New York, in Lower Manhattan, a man by the name of Henry Stimson. He calls him up on the phone. He says, "I need you to come to my office." Well, Stimson had just been named the head prosecutor of the Southern District of New York by then President Theodore Roosevelt. The Justice Department had a lot of information that the Sugar Trust was doing all of this illegal activity in New York relating to customs work, but Stimson had a budget of about $30,000 to hire lawyers. So the way he decided to hire lawyers on a $30,000 budget was just hire a bunch of recent law graduates from Yale, Harvard, and Columbia. And the dean of Harvard Law School, he went to the dean of Harvard Law School, James Barr Ames, and said, "I need a list of your best graduates." He says, "Well, Felix Frankfurter is the best graduate in the last 10 years. You should hire him." So Stimson offers him a job. Frankfurter accepts. They prosecute the Sugar Trust with Henry Stimson. Stimson then uses that success to run for governor of New York. And he's Theodore Roosevelt's, now ex-president Theodore Roosevelt's candidate for governor of New York. And Frankfurter takes a leave of absence from the prosecutor's office to kind of be an aide-de-camp to Stimson on the campaign trail. And lo and behold, he finds himself riding in a car with Theodore Roosevelt all over the state of New York. And he and TR are on first-name bases. I just want to here's a guy, 11 years old, no English, age 23, first-name basis with Theodore Roosevelt. That's a pretty amazing rise for any American. He and Theodore Roosevelt hit it off. And for the rest of TR's life, they are close friends through thick and thin. And he really is Stimson's guy. Stimson doesn't win the governorship. He's a terrible public speaker and politician. But the next president, President Taft, makes Stimson Secretary of War. And Stimson invites Frankfurter to basically be his right-hand man down in Washington. And that's when Frankfurter gets in a group house with some other young up-and-comers, all of whom have one thing in common. They all think William Howard Taft is a terrible president, and they want to reelect Theodore Roosevelt because only Theodore Roosevelt can sort of stand up for workers and for the rights of organized labor. And so they start a political salon at their house in DuPont Circle, right behind Kramer Books, for those of you who've ever been to Kramer Books on the north side of DuPont Circle. And they call their house the House of Truth. And the reason why they call it the House of Truth is because their favorite guest at the house is a justice on the Supreme Court of the United States, Oliver Wendell Holmes Jr., who famously thought there is no such thing as truth. So hence it became known as the House of Truth. A Boston lawyer who was often in town by the name of Louis Brandeis was another frequent guest. So that's how Frankfurter got to be very close friends with Oliver Wendell Holmes Jr. and very close friends with Louis Brandeis. He's in the administration. By 1914, Harvard calls. And the professor at Harvard says to a man, "We want Felix Frankfurter on our faculty." He's the first Jewish professor at Harvard Law School. There are only about 9 or 10 people on the faculty at the time. While he was at the House of Truth, helps found this magazine. He's one of the executors for the magazine. It's called The New Republic, with Herbert Crowley. And they're like a pro-Teddy Roosevelt publication. Right, they're determined to get Teddy Roosevelt reelected president. He makes a famous third-party run in 1912, and he loses. But Frankfurter goes off to Harvard, and he promises Herbert Crowley he'll keep contributing to the New Republic while he's at Harvard Law School, and he does so. He becomes really the foremost critic of the Supreme Court of the United States in the pages of the New Republic while he's teaching at Harvard. And he's so young when he's at Harvard by this point in 1914, that he gets to know all of the editors of the Harvard Law Review. He makes it his business to become friends with all the top students in the school. And that's when he starts his project. Don't go to the New York law firms. Don't go to the Boston law firms. The highest calling you can possibly achieve is public service. And he starts feeding people into Woodrow Wilson's administration, in 1914, 15, 16. And he gets called back to Washington during World War I to again, work in the War Department, where his specialty really becomes labor and stopping strikes domestically during the war. And he's sort of painted as a radical by like 1917, 1918, 1919. He starts to part company with the Wilson administration over the Palmer raids, which were, a response to the first Red Scare was to round up and deport a bunch of radical immigrants all over the country, which was led by this young Justice Department official named J. Edgar Hoover, who was, and Frankfurter accused both J. Edgar Hoover and the Attorney General A. Mitchell Palmer of a bunch of unconstitutional conduct during the Palmer raids. Frankfurter and another Harvard professor were appointed friend of the court to represent 23 immigrants who were rounded up in the Boston area, and they saved about 16 or 17 of them from deportation through their investigation. And he's tarred by Palmer and others as this radical. Hoover starts a file on Frankfurter in what was then known as the Bureau of Investigation. He's still teaching at Harvard. He's taken over some of the cases of Louis Brandeis, who's now a justice on the Supreme Court of the United States. Wilson nominates Brandeis in 1916 and is sort of allied with Holmes for different reasons, but they're usually on the same side in favor of economic regulation. And Frankfurter argues for the last time before the Supreme Court. He took over some of Brandeis's cases, and he succeeded in upholding minimum wage laws and maximum hour laws before the Supreme Court coming out of Oregon in 1916 and 1917. And 6 years later, Frankfurter was back at the Supreme Court in a case called Atkins versus Children's Hospital. Frankfurter and Brandeis thought they had successfully buried the decision of Lochner versus New York by upholding some of these minimum wage and maximum hour laws. But the Atkins case was about a DC minimum wage law for women. And Frankfurter thought, well, if I can just win now Chief Justice Taft's vote, right? Taft had gone from president to Chief Justice by this point. If I can just win Chief Justice Taft's vote, I can win the court. Well, he won Chief Justice Taft's vote, but he only won one other, Holmes. Brandeis was recused from the case. He lost 6-2. The court struck down the minimum wage law for women in the District of Columbia on a liberty of contract theory and said liberty of contract is the rule and the constitutionality of economic legislation is the exception. And this liberty of contract they found in the Due Process Clause of the 14th Amendment. Frankfurter was so upset after this decision that he wrote his buddy, learned hand, and he said, the Due Process Clause of the 14th Amendment gives the justices of the Supreme Court too much power. We should write it out of the Constitution. And Brandeis told him, if you did that, they would just find some other clause in the Constitution to strike down the economic legislation. But, Frankfurter's kind of anti-court worldview, this idea of the Supreme Court being anti-regulation, which started in Lochner, right, and continued to Atkins versus Children's Hospital, he holds all the way through until the early 30s. He doesn't give up hope, right? He throws himself into the political process. He joins Robert La Follette's third-party presidential campaign and endorses it in the New Republic in 1924. He tells his frenemy, Walter Lippmann, who's his pal that helped create the New Republic, he says, Walter, I don't care about 1924 when Lippmann says he's throwing away his vote. I care about 1944 and the direction of the country. In 1928, Frankfurter supports Al Smith's presidential campaign. He's, of course, the first Catholic nominee of any major political party. Smith gets trounced by Herbert Hoover. In between those two elections, Frankfurter writes a book about this little case of two Italian anarchists who are convicted of murder and robbery and sentenced to death. That's Sacco and Vanzetti. And he writes a book that shows the trial was completely unfair and that they were on trial for their anarchist political beliefs and not for what they had actually done. And there was little evidence to convict them. And that really got him excommunicated from the city of Boston. The Massachusetts State Police tapped his phones and transcribed the wiretaps, which was great for me, but bad for him. But they were following his every move, and he basically became kind of persona non grata in the city of Boston, and had a huge unsuccessful campaign to try to save Sacco and Vanzetti from the electric chair, and he obviously failed. But he doesn't lose hope in the electoral process. Walter Lippmann thinks after Al Smith loses in 1928 that the Democratic Party is over, right? He says the Democratic Party is dead, and Frankfurter says no. Walter Lippmann, by the way, is wrong about every single political event until Vietnam, when the broken clock is right one time, right? That's one thing I learned from writing 2 books about Walter Lippmann. But he says the Democratic Party is dead, and Frankfurter says, no, it's not. There's this guy named Franklin Roosevelt who just squeaked out a victory to be the governor of New York when Al Smith, the former governor, lost his own home state in the presidential election. It's totally remarkable. He's the future of the Democratic Party, and the Democratic Party is going to be the liberal party in this country. Now, that's a bold statement, right, in 1928, because there's, of course, liberals in the Republican Party in 1928 and in the Democratic Party, and there's conservatives in the Republican Party and in the Democratic Party in 1928. Frankfurter knew Franklin Roosevelt from working in the War Department. When Roosevelt was Assistant Secretary of the Navy, Frankfurter was the chair of something called the War Labor Policies Board, and he and Roosevelt became friends. Roosevelt famously invited Frankfurter over for lunch. And Eleanor wrote her mother-in-law what she thought of Frankfurter, and she said, an interesting little man, but very Jew, was Eleanor's response at the time. Obviously, she was not the enlightened Eleanor Roosevelt that she would later be. But so Frankfurter becomes this advisor to Governor Roosevelt, and on all sorts of subjects, on criminal law, on public utilities, on you name it. Roosevelt wanted to go to Frankfurter for advice. And this became critical after the stock market crashed in 1929 and state governments were hemorrhaging money. And so Frankfurter really became Roosevelt's chief outside advisor. So you can guess what happened, right? Roosevelt becomes president of the United States. He's elected in 1932. He takes over from Herbert Hoover in March of 1933, and he asks Frankfurter to be his Solicitor General. Solicitor General, for those of you who don't know, didn't go to law school, never want to go to law school, is the person who represents the United States government before the Supreme Court. He says, I need you to be the Solicitor General, and I want you to do all this other stuff for me too. And Frankfurter says, wait a second. He says, being the Solicitor General is a full-time job, and I cannot be the Solicitor General and be your outside advisor on 28 things. He says, I can help you more from the outside. And Roosevelt says, listen, I want to put you on the Supreme Court one of these days, and I can't just put the law professor who defended Sacco and Vanzetti and came out against the Palmer raids on the Supreme Court of the United States. Let me make you the Solicitor General. Frankfurter says no. He goes off to Oxford on a fellowship with his wife for a year. He's still advising Roosevelt, writing letters. He's got all these people by this time, right? All these former students in government, right? His former students flocked into the Roosevelt administration. People with names like Ben Cohen and Tom Corcoran, right, who write the 1933 Securities Act. So all of Frankfurter's students are all over the administration. In fact, people like Joe Kennedy, anti-Semites, start calling the New Deal the Jew deal. Right, that Frankfurter's this kind of Rasputin-like figure who has control of Roosevelt and has all these Jewish lawyers invading the government. And Frankfurter continues advising Roosevelt on all sorts of things until 1937. And that's when Roosevelt announces to the country he's going to try to pack the Supreme Court of the United States by appointing a new federal judge for everyone over the age of 70 who decides not to retire. And up to 6 Supreme Court justices. And he leaves Frankfurter in the dark. He writes him a letter and he says, listen, you're going to be in for a shock. Just reserve judgment until we talk. So they talked after this announcement. He had Congress was in the dark. All of his closest aides were in the dark. There were about 5 people in the know before the announcement of the court packing plan. And Frankfurter didn't agree with the idea of packing the court. But he thought the Supreme Court was out of control. right? By this time, it was striking down all of Roosevelt's early New Deal legislation as either exceeding Congress's power to regulate the Commerce Clause or as an unconstitutional delegation to an administrative agency, right, which is back again for those of you who have been following the Supreme Court and the student loan case. And so Frankfurter thinks the Supreme Court's out of control. He just doesn't see this as the right remedy. And Roosevelt says, listen, I need your help in making the case for my court reform bill. And Frankfurter, behind the scenes, writes Roosevelt his indictment of the Supreme Court of the United States, but he does not publicly say anything. He agrees to Roosevelt's request to remain publicly neutral about the court packing bill. And this outrages Frankfurter's Republican friends. Learned Hand is a Republican. He thinks Frankfurter ought to speak out about court packing, and a whole bunch of others. Republicans are like, why are you, being silent on this one issue when you speak out against everything else? Well, I think he did it out of loyalty to Roosevelt, and there was no kind of promise that Frankfurter would get a Supreme Court seat in exchange for being publicly neutral on court packing. Obviously, the court packing bill failed, but the Supreme Court started upholding New Deal legislation, in which some historians call the switch in time, that saved 9. And then Supreme Court justices started to retire, right? And the third vacancy went to Frankfurter. He replaced Benjamin Cardozo, but his nomination caused a firestorm, right? There were German Jews in New York who were advising Roosevelt, including Sulzberger, the publisher of the New York Times, not to put Frankfurter on the court because he feared the backlash and the anti-Semitism with the Nazi threat in Europe coming here to the United States with Frankfurter's nomination. Frankfurter became the first Supreme Court nominee to have to testify before the Senate Judiciary Committee in a no-holds-bar kind of interview by this really awful senator, Pat McCarran from Nevada, who was like Joe McCarthy before Joe McCarthy. And all these kooky people who saw communists everywhere in government were testified at Frankfurter's nomination hearing. This one woman accused several members of the Senate Judiciary Committee, as well as Franklin and Eleanor Roosevelt, of being communists. And she kind of melted down, but she made headlines. Frankfurter gets confirmed by voice vote. The senators did not want to be on record in how they voted on Frankfurter's confirmation because there was this fear that he'd be this liberal radical justice. Well, this weird thing happened. Frankfurter engaged in judicial restraint while on the Supreme Court, right? It wasn't like, oh, now I have the power, I'm going to suddenly become this judicial activist that strikes down legislation left and right. And he even becomes pretty controversial in liberal circles by upholding some pretty awful things, right? When he writes an 8-1 decision in a case called Minersville versus Gobitis and upholds a compulsory flag salute for Children of Jehovah's Witnesses. And then, a couple of years later, when the court reverses that decision, he writes a dissent and says, hey, we should leave school curricula up to schools, right? Think about PS 25 and Miss Hogan, and that's probably what's going on there, right? But he said we should leave school curricula to schools. If you don't like the public school curriculum, you can go to private school, right? Liberals didn't like that. But he didn't want to borrow Elena Kagan's phrase, weaponize the First Amendment to strike down pieces of economic legislation. And that sort of continues. But he made Frankfurter one big move that Holmes and Brandeis never made when they were on the Supreme Court. For Frankfurter, it wasn't judicial review all the way down. That's what Holmes and Brandeis thought. And they were not great on race. And in fact, they were quite bad on issues of using the 14th Amendment to make African Americans equal citizens. And Frankfurter saw that it couldn't just be judicial review all the way down, that you had to protect the rights of African Americans to be what he called, in a 1944 opinion called Smith versus Allwright, citizenship free from racial discrimination. right? That was a case that he was initially assigned. It was about the all-white primary in Alabama. Alabama was a one-party state. Whoever won the Democratic primary was elected to office. The Democratic Party excluded all black people from its primary, so black people had no say in who their elected officials were. Frankfurter was initially assigned the majority opinion. It required overruling a prior decision of the courts, but Robert Jackson, of all people, went to the Chief Justice, Harlan Fiske Stone, and said, hey, it's a bad look to have this Jew from Massachusetts overturn an Alabama all-white primary law. I think you ought to reassign this to a Southerner. And Stanley Reed writes this opinion, and Frankfurter thought, and he's a Kentuckian, Roosevelt's former Solicitor General. He writes this opinion, and Frankfurter thought it was awful. He said, you've done exactly what I told you not to do, which is you've got to forthrightly explain to the American people why you're overturning this precedent. And so he writes this draft concurrence and basically says, hey, we need to enforce the 14th Amendment. We've been wrong in the past. We need to enforce this 14th Amendment to protect the rights of black people so their citizenship is free from racial discrimination. He shows it to Jackson, and Jackson says, no, you can't publish that. And for the only time in his life, Frankfurter shelved one of his concurring opinions, which I reprinted in the book and published. And what that opinion showed to me, this was 44, 10 years before Brown versus Board of Education. What that opinion showed to me was that Brown was inevitable. Striking down separate but equal public schools, Frankfurter's vote to strike them down was inevitable, right? And you see it in subsequent decisions. In 1948, Frankfurter hires the first black law clerk at the Supreme Court of the United States, William T. Coleman. He's the future of Secretary of Transportation under Gerald Ford. His co-clerk is Elliot Richardson. They go, one day the Supreme Court cafeteria is closed, and so they decide to go to the Mayflower Hotel for lunch. Well, at the last minute, Elliot Richardson, right, Nixon's Attorney General during the Saturday Night Massacre, Elliot Richardson says, I have too much work. Well, he didn't have too much work. The Mayflower Hotel wouldn't serve black people in segregated Washington. So Elliot said, hey, Bill, why don't we go to Union Station and have lunch instead? And Union Station was one of the only places in Washington which was segregated, where a black person and a white person could have lunch together. And then there were a bunch of graduate school segregation cases that came up before the court right at the end of Bill Coleman's clerkship. And Coleman wrote this remarkable memo for Frankfurter about why these schools, what the NAACP did was very smart. They targeted law schools and other graduate schools where they had a law school for whites but no law school for blacks, so it could not possibly be separate but equal under Plessy versus Ferguson. I worked it in there, see? It couldn't possibly be separate but equal. And Coleman wrote this amazing memo for Frankfurter, which he showed subsequent clerks about why there's no way some makeshift law school in the state of Texas could possibly be equal to the University of Texas Law School. Right? That's a 1950 case called Sweat versus Painter, where they order Heman Sweat's admission into the University of Texas Law School. And by then, Brown versus Board of Education is a fait accompli. But, so flash forward 4 years, you've got a brand new Chief Justice. Brown's been argued one time, and the school desegregation case has been argued one time. The Chief Justice, Fred Vinson, dies of a heart attack in August of 1953. The new Chief Justice of Eisenhower selects is Earl Warren, and he's never argued a constitutional law case. He doesn't know a single thing about constitutional law, and he's thrown in to the most important constitutional law case of the 20th century, which is our separate but equal public schools constitutional. And he's not even confirmed by the United States Senate. He's nominated as a recess appointment, and he's not even confirmed until the spring of 1954. So this idea that Earl Warren, through his vast political skill, single-handedly created this unanimous opinion from all these disputatious justices, right? All these justices who were constantly at each other's throats, that he rallied them behind this one opinion is a falsehood. And I spend a lot of time in the book showing that the two justices who were really leading Frankfurter by the hand to unanimous result were Felix Frankfurter and Hugo Black of Alabama. And so, that was a huge triumph for the court as an institution and for Frankfurter. But it doesn't take long after Brown v. Board in 1954 for Frankfurter and Earl Warren to go crosswise, right? To really, like, Frankfurter really starts to part company from Earl Warren. And here's where the court kind of gets lost in the thicket. And let me tell you where that comes from. There was a case in 1946 about Illinois' congressional districts. And Frankfurter said, don't decide this case, right? He says, to sustain this action would cut very deep into the very being of Congress. Courts ought not to enter this political thicket. Well, the Warren court, now that they had this liberal majority of justices, they just started intervening left and right in all sorts of cases. And where Frankfurter and Warren really became at loggerheads was in a case 4 years after Brown called Cooper versus Aaron. And that's a case involving Orville Faubus, the segregationist governor of Arkansas, and he disobeyed a federal court order to continue with the desegregation of the Little Rock public schools after Eisenhower had sent in the 101st Airborne to integrate Little Rock Central High School with those 9 courageous students. And William Brennan is assigned the majority opinion by Earl Warren, and Brennan was Frankfurter's former student who becomes Warren's sort of lieutenant. And Brennan writes that the reason why Faubus is all wet is not because state governors ought to obey federal court orders, but because the Supreme Court has the last word on the Constitution. And Frankfurter and his colleague John Harlan, who was Robert Jackson's successor on the court, thought that was horrible. Tried to get Brennan to change it, and he wouldn't, and wouldn't take it out. And of course, Frankfurter signed onto the opinion because he wanted it to be unanimous. He thought what Faubus did was horrible. But to the consternation of all these colleagues, he wrote this long concurrence in which he was writing to really Southern lawyers and judges and said, look, this isn't about the Supreme Court having the last word on the Constitution. This is about obeying the rule of law, right? And so he's talking in a different register than the Warren court. And 4 years later, in the last case of Frankfurter's career, is a case called Baker versus Carr. Right, that's a case where the state of Tennessee had failed to reapportion its state legislative districts for 60 years. And remember what Frankfurter said about getting lost in the political thicket. Well, he's adamant that the court shouldn't decide this case, that it was up to Congress to reform the state of Tennessee using its constitutional powers, and maybe not seeing the Tennessee legislature, right, the Tennessee delegation in Congress. And there are other remedies than judicial ones. And so he dissents. He writes this long, impassioned dissent. But in that Baker versus Carr majority opinion, it's a 6-2 opinion, William Brennan says, and I quote, he says, the Supreme Court is the ultimate constitutional interpreter, right? He makes super plain that the Supreme Court has the last word and possibly the only word on the meaning of the Constitution. And that's really anathema to everything Frankfurter stood for. He believed that Congress and the executive branch had co-equal roles in interpreting the Constitution. And that's why the court shouldn't involve itself in electoral disputes. That really speaks to me. I'll tell you why in a minute. I'll finish up with Frankfurter's career. He had a stroke shortly after Baker versus Carr gets decided. He was forced to resign before the court started in 1962. One of his best law clerks was a guy named Alexander Bickel. He became this famous professor at Yale Law School. And he wrote this book in 1962, which Frankfurter was too ill to read. It was called The Least Dangerous Branch. And it's really about the anti-democratic or counter-majoritarian role that the court plays when it exercises its power of judicial review to strike down a law. And Frankfurter didn't read the book, but he had one response to the book, which was the title. He said, what's so dangerous about the other two branches? And that's really his philosophy in a nutshell. Here's why Frankfurter's philosophy really speaks to me personally, and why I got interested in the book, and where its power really is today. I graduated law school in 1999, about 3 years after the Supreme Court of the United States eviscerated Congress's role in enforcing the 14th Amendment. I mean, it's called Section 5 of the 14th Amendment, and the court basically said in a case called City of Bernie versus Flores that we first have to identify the constitutional violation, and then you, Congress, can follow our lead and remedy it. This is the ultimate constitutional interpreter idea, and it's completely backwards from the text of the document. The second thunderclap for me was Bush versus Gore. Right, that was in 2000, where the Supreme Court intervenes in an electoral dispute, right, stops the state of Florida's recount. For some of you who are too young to remember, I see some young people in the audience. My students, when I talk about the 2000 recount, they look at me like, what are you talking about? I was 3 years old. Well, the state of Florida was recounting its electoral, its ballots, and the fate of the presidential election hung in the balance. And the Florida Supreme Court ordered the recount in only a few counties, and the Supreme Court of the United States said, you can't do that. Well, they should have just stayed out of it, because that recount showed that Bush won anyway. What the Supreme Court did was decided on this flimsy equal protection rationale that was really good for that train only. Well, that's not the way the Supreme Court's supposed to decide cases. They're supposed to say, here's what the Constitution means, and it applies to a bunch of different factual circumstances. It's not a boxing referee in a ring that just holds up one side's hand and not the other. It issues decisions based on principle and reasons. And I think Bush v. Gore was really the moment when the legal academy started to realize that Frankfurter might be right, that the Supreme Court's become too powerful, that it's too eager to strike down federal laws, that it's too eager to strike down economic legislation that it doesn't agree with. And then that crescendo starts really growing and growing and growing when the court strikes down the Voting Rights Act, Section 4B of the Voting Rights Act, where it really guts Congress's oversight of state elections in Shelby County versus Holder. And then it grows a little more when the court overrules Roe versus Wade. People ask me, did you write this book to time it for when Roe versus Wade overruled? I'm like, of course not. I've been working on this book for years. It's 600 plus pages. I don't work that fast. And now I think in some of the more recent decisions, particularly the one to me that's completely antithetical to Frankfurter's worldview, is the student loan decision, Biden versus Nebraska, that a statute based on the plain language of that statute delegated power to administrative agencies to suspend student loan payments and to alter student loan payments. This is what Frankfurter and his liberal colleagues fought against this conservative court in 1935, against things like the non-delegation doctrine, this idea that Congress can't just delegate too much power to the administrative agencies. Well, that battle was fought and won by Franklin Roosevelt and his colleagues in 1937, but here we are again fighting those same battles. I'm going to stop there. I will answer any question about Felix Frankfurter, any question about the current Supreme Court. I am not going to steal my friend Justin Driver's thunder about the affirmative action cases, but I will take questions on that too. So you name it, and I'll answer it. Usually, I call on people, but I'm not allowed to do that. So
if you raise your hand and write a note. Thank you, Brad. That was terrific. And I want everybody to sort of transform themselves to October of 1954. October 1954, late in the afternoon, after Robert Jackson's funeral, there was 5 Cadillacs. 5 Cadillacs went from Jamestown up this side of the lake and came through Chautauqua Institution. And one of those Cadillacs carried Felix Frankfurter. So if you flash back a little bit, you can visualize at about this time, in October of 1954, a black Cadillac, and there would be Felix Frankfurter kind of driving by, and spiritually today, he's driving by listening to you, Brad, and I'm sure he would approve. While the questions are coming up. You did talk about the Brown versus Board of Education. You did talk about the transformation of the court on the death of Chief Justice Vinson. Purportedly, your guy said something when he got the word of the passing of Chief Justice Vinson.
Yeah, well, Frankfurter left the synagogue at age 15 and never went back, right? He didn't believe in God, and he thought he would be a hypocrite to keep going to synagogue. So his religion was really democracy for the rest of his life after that point. But when Fred Vinson died, he thought Vinson, who had served in all three branches of government, he'd been Secretary of Treasury, he'd been a federal judge, he'd been in Congress, but he was really miscast as Chief Justice. And Frankfurter said to his law clerk at the time, Alexander Bickel, he said, this is the first indication I've ever had that there's a God, when Vinson died. And that wasn't a really nice thing to say, and Frankfurter had some hard edges to his personality. He could alienate his colleagues with the best of them, but I think what he meant was that there was no way the court was going to be unanimous under Fred Vinson in a school desegregation case, that Vinson had lost control of the court. Robert Jackson, Hugo Black, William O. Douglas, and Felix Frankfurter were four difficult personalities and big personalities, and Fred Vinson was really incapable of controlling them. So I know that sounds like a harsh thing to say, but he saw about 3 or 4 different opinions overruling segregated schools if Fred Vinson had been the Chief Justice, and he saw an opportunity for a unanimous court under a new chief.
I got a question here. If Frankfurter's judicial restraint exception was racial issues, why did he concur on the Korematsu case?
Great question. So Korematsu, for those of you who didn't go to law school, was a case brought by a man named Fred Korematsu, who refused to evacuate when President Roosevelt issued his executive order evacuating Japanese Americans from the West Coast after Pearl Harbor, because he was told that they were a security threat. And so they were not only evacuated, they were eventually put in internment camps. And so Fred Korematsu was challenging that evacuation order. I wrote in my book that one of the not great things about Felix Frankfurter's time on the Supreme Court was he never stopped advising Franklin Roosevelt. In fact, he got his old mentor, Henry Stimson, installed as Secretary of War before Pearl Harbor because he knew America was going to war. And he had a former student named John McCloy, who was Stimson's right-hand person in the War Department. And Frankfurter was advising Stimson and McCloy almost every day. And I wrote in the book that Frankfurter should not have been doing that, even though other justices were at the time. It still doesn't make it right. But B, he certainly should have recused himself from the Korematsu case. There's no reason why he could sit on that case. He was too closely involved in wartime policy making. So I think in both that case and another one I singled out was about the case of the 8 Nazi saboteurs, ex parte Quirin, which they were tried by military commissions. Well, Frankfurter had advised Stimson on whether or not to have a military commission in that case. He shouldn't have been sitting on that one either. I think Frankfurter was much like Hugo Black, who was both his friend and enemy, ideological enemy but personal friend. They both thought that there's no way they're going to tell a wartime president, and someone that Frankfurter considered Franklin Roosevelt the greatest president since Abraham Lincoln. There was no way during a war that Frankfurter was going to dissent from a wartime president. But Robert Jackson and Frank Murphy and Owen Roberts had the courage of their convictions, and they dissented in the Korematsu case, and good for them.
You talked about the Jehovah's Witness case, talked about the Gabaitis case in 1940, Minersville versus Gabaitis, and then, of course, West Virginia versus Barnett, of which the court kind of did a 180, and Frankfurter was on the outs. I mean, he clearly was mad.
Yeah.
And he wrote the dissent in Barnett. Here we are on the 80th anniversary of that You care to comment on that?
On the 80th anniversary?
Barnett case, 80th anniversary.
Well, look,
Barnett case.
Robert Jackson, one of his greatest judicial opinions in his majority opinion in West Virginia versus Barnett, he was brand new to the Supreme Court of the
That's why I
United
wanted you to talk about that.
States. I mean, it's beautifully written. It's beautiful, right? And I can't recount the language from memory, but, there's no star, and I can't quote it. Greg, you probably can, but I can't. Yeah. Thank you so much. I mean, it's
Kristen
beautiful.
McMahon, by the way, the Robert Jackson Center, very good.
But I will say, though, that Jackson's opinion is very judicially supremacist. I mean, it's increasing the Supreme Court's role in policing state and federal laws and ferreting out violations of free speech. And it was Jackson who transformed the Gabitis case, which was a free exercise claim, right, a freedom of religion claim brought by these parents of Jehovah's Witnesses, and it was Jackson who transformed it into a free speech case, right, a compelled speech case. And if you look now about West Virginia versus Barnett, it's being used by the current court's conservative majority to create carve-outs to things like anti-discrimination laws, right? The case they always cite first is Barnett. This weaponization of the First Amendment was really started by, I hate to say it, Robert Jackson. And I have great admiration for Robert Jackson. So you can see where Frankfurter's fears were. He didn't like the idea of compelling children of Jehovah's Witnesses to salute the flag, but he also didn't want the Supreme Court to use the First Amendment and free speech as this sort of perpetual censor against state legislatures.
Which current Supreme Court justice do you believe is most like Frankfurter in his judicial philosophy?
Well, so I'm going to name one who recently retired and one who's currently on the court. They both happen to go to Harvard Law School. One is Stephen Breyer, who recently retired, and I think had a kind of minimalist view of the court's role. And I'd say the current justice who's closest is Elena Kagan, who's the former dean of Harvard Law School and a former Solicitor General for President Obama. She very much believes in following precedent, and with the exception of separate but equal, Frankfurter was very much encouraging his liberal Warren Court colleagues not to overturn these precedents left and right, because liberals aren't going to be in charge of the Supreme Court of the United States, right? He saw the Warren Court for what it was, which was a liberal aberration in a historically conservative institution. So I'd say Kagan embodies Frankfurter's respect for precedent. She's a much better writer than he is, though, by the way.
What constitutional provision would Frankfurter use to argue against the current court's made-up questions doctrine?
Oh, I think
Better explain the questions doctrine.
Yeah. So the Supreme Court has revived the non-delegation doctrine, which I mentioned a couple times in my talk. This is the idea that Congress can't just pass a law giving a blank check to an administrative agency. Like Congress, everybody sort of agrees in law that Congress can't pass a law that says, administrative agency, you can do whatever you want, right? That would be illegal. You can pass whatever regulations you want. Well, Congress has to give guidance to those administrative agencies and the types of regulations it's supposed to be passing. And the Supreme Court has revived that non-delegation doctrine, but given it a new name. And they call it the major questions doctrine, right? Justice Gorsuch has said in one of his concurring opinions that the major questions doctrine and the non-delegation doctrine are essentially the same thing. That means that, like, when there's a really big issue, Congress really has to tell the administrative agency specifically if it's a big deal, like student loan forgiveness on a massive scale, that the administrative agencies can do that. And so what the Supreme Court, current court, is doing is using the major questions doctrine to chip away at the administrative state and to chip away at sort of economic, broadly written economic regulations that are implemented by agencies. And that's really disconcerting for people who think that we as a country evolved after the Great Depression and after 1932, that we needed to regulate capitalism, that we needed to have experts at administrative agencies helping Congress to regulate capitalism. And I think people on the left are fearful that we are unlearning the lessons that we learned during that court-packing crisis from 1935, 1936, and 1937.
What's your opinion on the Citizens United case? Your opinion, Brad.
My opinion, Brad Snyder's opinion. Well, so I want to cheat and say I know what Frankfurter's opinion would be, right? He wouldn't strike a law down unless it's unconstitutional beyond a reasonable doubt. I haven't read that case in a while. Citizens United struck down the McCain-Feingold campaign finance laws. This is, to me, what Frankfurter was worried about in West Virginia versus Barnett. If you can just say First Amendment, free speech, and strike down laws, I think I'm all for free speech, free press, freedom of assembly. I'm writing a book on a free speech and free assembly case, but I think like any other constitutional right, it has limits, right? It's not absolute. And that as long as government, state, and federal are reasonable in how they modify people's or maybe abridge people's First Amendment rights, then that's what it comes down to. And I didn't see the McCain-Feingold legislation as triggering that kind of First Amendment censor. So I would have been in dissent on Citizens United.
A little bit different. Could you comment on Felix Frankfurter's reaction to the report from a young Polish diplomat about the Holocaust in 1943 and 44?
Yeah, I get this question every time I speak. The reference of the question is a man named Jan Karski. If anybody has seen the Shoah documentary, he's interviewed in the documentary. He's incredibly charismatic, and he's an amazing story. He was taken he swore to the people of the Polish resistance to the Nazis that he would tell the world what happened in Poland. He eventually becomes a Georgetown University professor. And he's an amazing man. David Strathairn recently played him in a one-man show. So everything I'm about to say is not a knock on Jan Karski. He was taken behind enemy lines, if I want to say in like an Estonian army uniform, and he physically witnessed what was happening in concentration camps and about the slaughter of the Jewish people, both in Poland but also at the camps. And first he went to England, and then he came to the United States to tell his story. And most people, when they wanted to go see FDR about issues relating to Jews, they went to Felix Frankfurter first, because they knew about Frankfurter's relationship with FDR. And Karski and the Polish ambassador meet with Frankfurter, and according to Karski, he told FDR what was happening, and Frankfurter says, "I can't believe it, right? I can't believe it, right? This is too horrible for me to believe. I can't believe you." And I think that needs a little bit of context. Frankfurter knew more about what was going on in Europe than just about anybody in America. He had family in Vienna. He saved his uncle from a Nazi prison. And in fact, so I figured out that Karski, and look, everything needs context, right? So I saw the outtakes to the Shoah documentary and viewed Karski's interview in full. It's amazing. I don't think Karski was saying that Frankfurter didn't believe him, or he wasn't calling Karski a liar. I think what Frankfurter was saying, that in my heart, I don't want to believe that these atrocities you're telling me are true. But I know for a fact that Frankfurter knew all about them 6 months before Karski ever walked through the door of his chambers, because the Polish government in exile in December of 1942 sent Frankfurter information about what was happening. Right? I found it in Frankfurter's files. So Frankfurter knew in December of 1942 about Polish atrocities. But I think it's one thing to read a piece of paper about what's happening to the slaughtering of Polish Jews, and it's another thing to have somebody tell you what the concentration camps looked like, sounded like, smelled like, etc. And so by the summer of 43, Frankfurter knew what had happened. And so, that Karski thing says, oh, Frankfurter didn't believe Jan Karski. No, I don't think that's what happened. So, that Frankfurter didn't believe Jan Karski. I think Frankfurter believed him, but he didn't want to believe that human beings were capable of doing that to another human being.
You've had this audience rapt attention, I'm paying close attention to your eyes, and trying to figure out when's a good time to end. And I don't think you'll ever end if the attention they've had to your responses. So I applaud the audience for their attention, but we have to end. What's the question I haven't asked you, Brad, that I should have?
Well, the question I usually get is, how would Frankfurter have decided the Dobbs abortion decision, right? It's kind of the most popular one, and it's on kind of people's minds. And I think in 1973, when Roe versus Wade had been decided, that Frankfurter would have been very uncomfortable using the due process clause that he abhorred to find this kind of liberty right to an abortion, right? I think he would have been more comfortable using the equal protection clause to say, no, this is about the equality of women and not some sort of due process liberty. But that's really irrelevant, right? The question is, 40-some odd years later, nearly 50 years later, would Frankfurter have overturned Roe versus Wade? No way in hell, right? Like, he didn't overturn precedents like that. That's what he was warning his Warren Court colleagues about. So there is no way he would have been in the majority in Dobbs overturning Roe versus Wade. He would have been in dissent saying, what are you doing? You're not just overturning Roe versus Wade, you're overturning Planned Parenthood versus Casey. You can't knock down Supreme Court precedents like bowling pins. So that's the question I usually get asked. This was, by the way, super fun for me. I really enjoyed this audience and doing this. Thank you so much.